Thank you. Until the air conditioning doesn't work in this place, so we are hot. And so both doors just kept open. And if you need be, we can move the fan downstairs if you desperately want some cold air downstairs. Let us know.
Thank you.
If we see you fall asleep, we'll know we need it. Thank you, Ms. Pillay.
Thank you very much. Justices, I had started before the two adjournment my brief submissions on remedy in relation to the reading in. I'm going to now move on to setting out what the principles are before I deal with the question of the application of those principles. Principle 1, members of the court, on a reading in remedy is that the order must vindicate the rule of law and thereby ensure that there's sufficient precision and no vagueness in any order that is put forth. And this court will be guided on this principle when it has regard to the corruption watch judgment, which is in the DA's main bundle of authorities. It appears at page 304. You need not go there. But paragraph 68 of that judgment, where the Constitutional Court says there's no preordained consequence that must flow from a declaration of invalidity. The court may make an order that's just and equitable in terms of section 172(1)(b of the Constitution. And the operative word any is as wide as it sounds. Wide though its jurisdiction may be, it is not unbridled. It is bounded by the very two factors stipulated in the section, justice and equity. And the court has laid down certain principles in charting the path on the exercise of the discretion to determine the just and equitable remedy. Importantly for our purposes, the court goes on, what must be paramount in the relief that a court grants is the vindication of the rule of law. The second judgment on that line isn't one that's been referred to in our heads, but it's a trite principle. It's a judgment of the Constitutional Court in Affordable Medicines, and it's at paragraph 108 of that judgment, where the Constitutional Court says the doctrine of vagueness is one of the principles of common law that was developed by our courts to regulate the exercise of public power. As pointed out, it's now regulated by the Constitution, and the doctrine of vagueness is founded on the rule of law, which, as pointed out, is foundational to our constitutional democracy. Here's the important part. It requires that laws must be written in a clear and accessible manner, and what is required is reasonable certainty, not perfect lucidity. The doctrine of vagueness does not require absolute certainty, but it must indicate with reasonable certainty to those who are bound by it what is required of them, so that they may regulate their conduct accordingly. Now, I must make clear, I'm relying on this dictum of the Constitutional Court for the purposes of the reading in remedy. Obviously, it's not a vagueness in the statute as it stands, but for the purposes of the reading in remedy. And the submission is, if that's the standard that the legislature is held to, in terms of laws being written with reasonable certainty, this court ought to be held to a similar threshold. And we know that other cases have spoken about sufficient precision in an order that it grants. Justices, the third relevant case of the Constitutional Court is the National Coalition for Gay and Lesbian Equality versus Minister of Home Affairs. It appears at page 948 of our main bundle. And if I may direct the court to paragraph 75 of that judgment. There the Constitutional Court said, in deciding to read words into a statute, a court should also bear in mind that it will not be appropriate to read words in unless in doing so it can define with sufficient precision how the state ought to be, as how the statute ought to be extended to comply with the Constitution. So the threshold there is sufficient precision on the reading in. Justices, the second principle is what I refer to as the Doward principle. The Doward judgment appears at page 326 of our main bundle of authorities. And if I may direct the court's attention to paragraph 63 and 64 of that judgment. I'm not going to read the whole thing, but in relevant part, the Constitutional Court said it's paragraph 63. It would be inappropriate for this court to seek to remedy the inconsistency in the legislation under review. The task of determining what guidance should be given to decision makers, and in particular the circumstances under which a permit may be justifiably refused, is primarily a task for the legislature and should be undertaken by it. I accept readily the subject in Doward was very different to the subject in respect of what this court's dealing with here, but I'll come to that in a moment. But importantly, the Constitutional Court went on to say there is a range of possibilities that the legislature may adopt to cure the unconstitutionality. And it went on to give examples of what those were. And then at 64 it said, whereas in the present case, a range of possibilities exists, and the court is able to afford appropriate interim relief to the affected persons, it will ordinarily be appropriate to leave the legislature to determine in the first instance how the unconstitutionality should be cured. And then with emphasis it said, this court should be slow to make those choices, which are primarily choices that are suitable for the legislature. And then the third guardrail was recognized by the Constitutional Court in the recent, I call it the EFF Kalapala judgment. It appears in our bundle at page 470. And if I may direct the court's attention to paragraphs 161 and 162 of that judgment. And there the Chief Justice said, and I'm not dealing with the outcome in that matter, I'm dealing with the legal principle that ought to guide this court. And there the Chief Justice said, the entirety of this exercise would occur within the bounds of the impugned rule. The severance and reading in combination would involve, and she said, 1, no major textual surgery that would be fraught with complications, thereby making severance impracticable. Substitution of the NA's policy choices on a mechanism, save to exclude the impermissible, enduring prescriptions to the NA as to what it should insert into the mechanistic gap, if any, and here's the important part, any substantial interference with or augmentation of the architecture and scheme of that mechanism or its foundational definitions or thresholds. And so I would submit that those are the three guardrails that we in this matter that we submit ought to guide this court in a reading in ring. And that must be done against my primary submission, which is the Act hasn't come into operation yet. There's no lacuna in the law. There's no interim relief that is required to vindicate, to be vindicated in this matter. And in those circumstances, this court would ask whether a reading in ring is competent or appropriate. Then let me go to the facts, Justices. It may appear at first blush that this is a relatively uncomplicated matter when it comes to remedy. But I'd submit to the court that the affidavits that have been filed by the state respondents show something quite different. And I'm going to refer the court first to the NA's affidavit. And the court needn't go there, but it's paragraph 60, 60, 61, and 73, please. And there the legislatures seek to delete reference to the word notice of expropriation in section 19, the relevant subs, and to have it refer to a written statement in terms of section 7(4)A Roman. So let me just mark that as that being proposal 1 that comes to this court from Parliament. And Parliament says that this inconsistency, says, in section 19 arises from the fact that it erroneously did not make the necessary consequential amendments, and therefore the reference to notice of expropriation is incorrect. It says that at 006-94 at paragraph 60. Parliament then goes on to say the correct interpretation, and here's the important part, consistent with the NA's deliberations relating to section 19, relates to the point at which the dispute arises, and it's on delivery of the written statement by the disputing party in terms of section 7(4)A, not on delivery of the notice of expropriation. The NA then goes on to say that this interpretation is consistent with its deliberations and the legislative process which it has spoken to. It says that at paragraph 66 at page 006-96. And then it makes a detailed proposal on how the remedy should, on how the section should read at paragraph 72 at page 006-98. The important takeaway, Justices, is what's also said at paragraph 73 and 74 of the NA's affidavit. The important thing is that the section 19 doesn't reflect the intention of Parliament. The reading in that Parliament proposes correctly reflects the intention of Parliament. And this court should therefore give credence to that as a way of dealing with the unconstitutionality. Now, importantly, that reading in refers to the written statement in section 7(4) of the Expropriation Act. So that's proposal 1 of what this court has before it. I'll come to the fact that Parliament has abandoned that in its text argument, and it's now aligned with what the President says. This after telling this court that its proposal, as set out in its affidavit, accorded with the legislative intention. Then proposal 2 comes from the President, Justices. And he says that the court should delete the reference to the notice of expropriation in section 19, and instead it should refer to when the mediation envisaged in 19(1) is terminated without settling the issues, or where there's no mediation effective, the notice in section 7(4). But importantly, what the President tells this court is that the section 19 as it currently reads is again not aligned with the process that was intended by Parliament at the time at which the bill was drafted. And it says that the intention of Parliament is apparent from other provisions. The court need not go there, but the reference is at 005-33, paragraphs 88 to 91. And then he goes on at paragraph 91 to say that sections 19, 2, 3, and 4 are not consistent with parliamentary intention and create a circular process. And then the important thing at what he says at paragraphs 96 and 97, which appears at 005-35, because there he says that his proposed reading in accords with what was intended by the legislature and would give effect to the legislature's intention. So he gives one version for the reading in based on legislative intention, and Parliament gives another version based on legislative intention. And then we have yet a third version that's presented to this court by the Minister of Rural Affairs. And the Minister of Rural Affairs says that he, on the one hand, he aligns himself with the President's remedy, and he says this at 23-10 at paragraph 26. But in his heads of argument, he says that what it should be substituted with is the notice of intention to expropriate. So, 3 different versions as to how the reading in ought to apply. And the court will look at those 3 versions against paragraphs 63 and 64 of Doward, and the court would ask itself whether a reading in would be appropriate and competent in these circumstances. Now, we've counted, and we may have missed some, but there are in fact potentially 9 different ways of resolving the difficulty that Section 19 presents. I'm going to ask the court to go to Section 19. I think it most helpfully appears in the legislature's bundle of statutes. It appears at page 10 of that bundle. And the court's attention will be drawn to section 2, sub 2 of that act, which speaks to its application. It appears at page 12 of the court looking. It says, subject to section 20, a power to expropriate a property may not be exercised unless the expropriating authority has without success attempted to reach agreement with the owner or holder of the right for the purposes of acquisition thereof on reasonable terms. Then the court will have regard to section 5, which speaks to the investigation and information gathering phase. After that process, the court will know that there's a notice of intention to expropriate. And justices, that appears at section 7. And the court will see that notice says, if the expropriating authority intends to expropriate, it must serve a notice of intention to expropriate on the various persons. That's under 7.1a. And then it tells us in 7.2 what that notice of intention to expropriate must include. And in A, it must include a statement of the intention to expropriate. And in 2H, it must include an invitation to an affected person to lodge within 30 days after the publication of the notice any objections to the intended expropriation, submissions relating to the intended expropriation, and issues around postal addresses and the like. And then, members of the court, subsection E refers to an offer of compensation which the expropriating authority considers just and equitable, with an explanation of how the amount was arrived at, together with supporting documents. So the important takeaway is on rural affairs position, the Minister of Rural Affairs position, is that 180-day time period in section 19 starts running from the date of issue of this notice of intention to expropriate. On Parliament's initial position is that it starts running from the date on which there's a response to this notice. And there, Justices, you'll find it at 7.4a Roman 3. That's when
My attention is drawn that your time is slipping away very fast, and you just dealt with
Thank you.
part of the.
I'll be cautious. Thank you.
We just stop there on the notice of intention. That cuts into the time in which the person has to consider, to ask further particulars. So it's not helpful because it cuts into the time.
It cuts into the time, but of course that's a critical question, Justice Saldana, because it underpins in my submission a critical policy consideration. Because what one's doing ultimately is you're trying to balance two competing demands. On the one hand, giving the parties a proper opportunity to try and settle this without needing to go to court. On the other hand, going to court to achieve finality, expediency, and allow the show to get on the road. And where you cut on one, you're potentially increasing on the other. And that's where it becomes quite difficult in how that balancing exercise goes.
I'm not too sure it's a competing policy choice, because if Parliament's intention is to treat people fairly, then you've got to give them an appropriate amount of time to consider, to themselves investigate, to ask further particulars, and then to make a decision on advice.
Yes.
You can't cut into that time.
Yes, I agree with that. I'm not.
So I'm not too sure it's irreconcilable with a sense that people need to be given proper time to consider, and then afterwards exercise their options.
So the only point I make these submissions to the court on the basis of what's the proper parameters, the guardrails that the court must apply when looking at the
But
regulation.
sensibly, no court's going to cut into the appropriate time for them to consider.
Well, the court will also consider the fact that this is, of course, a proposal that's been put up.
It's a proposal. It's one of many
by the
proposals,
Minister of
in
Land
fairness.
Affairs.
So one doesn't have to overstate the proposal. If the principle is that people must be given sufficient time to consider, take advice, and then formulate a view.
Yes,
We can't cut into that.
I accept that, Justice Saldana. I'm addressing the different options in the context of the range of choices that the Dower judgment refers to.
But is that really an appropriate choice to cut into time?
It's one.
Is it an appropriate choice for this court to make?
I'm going to come to that, Justice Saldana. I'm going to come to what's the proper parameters within which. But for the moment, I don't put it any more highly than to say that that's the proposal that Land Affairs has come to this court with, and I'm raising it in that context. Justices, you'll then see there's then the notice of expropriation in section 8. And the court will be well aware of the wording in section 19. But there is one point I'd like to deal with in 19, if the court could go there. It's at page 18. It says, if the expropriating authority and the disputing party do not agree on the amount time and manner of payment, they may attempt to settle the dispute by mediation, which must be initiated and finalized without undue delay by either party. So that's the opportunity to mediate before and settle it before going to court. And then, of course, it's in that context that 19.2 needs to be read. Let me then, in having made those submissions, Justices, take you to what we've submitted are the different options as to how this may be remedied. The first option, I may have referred to 9, the first option is from the date of expropriation. The second option is from the date of the written statement in section 7.4a. The third option may be from the date on which the parties commence negotiations. And there is a value in that. I'm not raising it in order to problematize it.
Sorry, when you say that, commencing negotiations, you're referring to the written statement?
No, I'm referring to an opportunity to negotiate after the written statement. And so, of course, what that might mean is that if one were to run it from the implicit in that is that there's a specific time frame given for negotiations to take place, and those negotiations must be concluded within that time frame, after which an order to court is complete.
I'm trying to get, that is not currently in the statute, the time for negotiation.
No, it
Okay,
isn't.
all right.
It isn't. There's
So that would be an insertion.
That would be
something new. Okay.
That would be so, Justice Montgomery. The other, it may be that it runs from the date on which the parties refer the matter to mediation by agreement. So assuming you've got your 19.1 duty, there's no quibble about it, both parties agree we're referring to it to mediation. And then the question is, at what point should the time kick in as from that point? It may be from the date where either one of the parties propose mediation. And the value of that is that it brings the other party to the mediating table quite soon after that. Or it may be the date on which either party terminates the mediation. It may also be that it's appropriate not to have a time limit at all in the section. It may be that it's appropriate to have a deeming provision when there's an impasse and at what point. We know the Labour Relations Act has a 30-day period as to when there's a hard stop on it. And it may be that there might be an increase or decrease of the 180-day time period. Now, Justices, the purpose of all of that is to show that there are a number of ways in which this can be resolved.
Mr. Pillay, the time periods for negotiating and mediation, are those not appropriately dealt with in rules?
Well, what we're told is that because Section 19.1 says that it must commence and be concluded without undue delay, I think is the word.
Yes.
That doesn't yield any uncertainty around it. But of course, this, certainly in my reading of it, there's no indication that this is an issue for deferral in rules or any of that. Justice.
Well, let's just stop for a second. So assuming the matter is to go to mediation, there's no indication as to how long the mediation will take place. And surely there should be rules that indicate how long mediation should take place. It can't be indefinite, because parties will drag it out. And you don't want parties to drag it out, and so you've got to give them guidance. And the mechanics for guidance is to be found more often than not in rules. You can't have a statute determine how long it's going to take for you to find a mediator who's going to pay for the mediation, the backwards and forwards. Mediation, of course, is a voluntary process.
Yes.
And people will need time to consider their positions.
Yes. Yes.
I suspect all of that may best be dealt with by way of rules.
Well, Justice Saldana, that's an interesting point, because that's not the case, of course, in terms of the legislatures or anybody else having come in and said, look,
Well, they haven't dealt with the issue of that, and do we have to deal with it? Because that's what the rules provision is there for, to deal with the minutiae as to how proceedings are going to take place. And the spirit in it must be done as soon as possible. But the thing is, there will be people who will try and drag it out for whatever reason. And so who gives them guidance?
well, it certainly wouldn't. Perhaps there may well be processes that follow on here. For the moment, the submissions I'm making are directed at whether it's competent for this court to make a reading in order in light of the different options that are available. And that's around a statutory prescript. It's not around a deferral of those options. So the statute.
I accept that, but I'm talking about the minutiae of negotiations, the time period, and mediation. It's there. The Act doesn't say how long the negotiations must take place, as my sister has raised, and neither does the Act indicate how long the mediation should take place.
Yes.
Because those matters are dealt with more appropriately by rules.
Just so then, the real issue there is whether or not this court can grant a reading in order with sufficient precision. And my submission would be that it may well be conceivable that aspects can be dealt with in rules. But the order that this court grants, if it's going to go down the road of reading in, it has to be one of sufficient precision. Justices, the second leg of it is the question of the uncertainties around mediation. And the proposed reading in must be read against the backdrop of Section 19.1. And that means that it pivots on a condition of an attempt to mediate. And so if the parties attempt to mediate, then the 180-day period commences from the date of termination of mediation. And then if they don't, it goes back to the written statement in 74. And we submit that there are difficulties with this. At what point does a party attempt to mediate? How much time is given to that? And we submit that without clear guidance from the statute itself as to how those details are to be regulated, it's unhelpful with respect to simply refer it to a rulemaking function.
But is the attack on 19.1?
Sorry?
No,
I'm saying that the reading in is based on what the reading into 19.2 flows from 19.1. That's the point. And of course 19.1 gives no certainty as to all of these other things. So by importing it into 19.2 as a hard guillotine, it poses problems. And the submission is, of course, we know from the affidavits that the earlier version of this bill referred to a notice of expropriation. And the notice had a hard, firm, clear, objective date, and it was easy enough to say 180 days from that. My submission is when you move it to the now new reading in order, it isn't clear. And given that it serves the purpose of acting as a guillotine, it doesn't meet the threshold of sufficient precision by this court. Justices, those are my submissions in respect of the Section 19 point. And let me then move very quickly in the interest of time to the mandates point. On the mandates point, there are, again, two threshold questions that I have to meet. The first is the question of jurisdiction, and there we're told that we're out on territorial jurisdiction and that the DA is out on exclusive jurisdiction. Now, on the question of territorial jurisdiction, The court will then have regard to section 21 and what it refers to in order to establish territorial jurisdiction. And we submit, when the court looks at section 21, it must have regard to this court's judgment in Norkia. Now that judgment appears at our main bundle at page 24-972. And Justices, you will recall.
See, I'm listening with this ear.
It will help if you can tell us which number of bundle it is.
24.
No. You've given
Oh.
us all bundles numbered. You can tell us which number it's.
Because it's 972, it's page 972.
So we have 7 bundles. Which bundle is it?
I have
Or is
4
it
bundles.
one like this?
No, that's the supplementary bundle.
No, this is
What page
applicant's
is?
list of authorities.
I'm sorry.
This is applicant's list of authorities.
Oh,
This is the supplementary.
Okay. It's the main bundle. That's right. Yeah.
972.
What's that reference again, Mr. Gay?
972. Justices.
Bundle do you have?
Oh, the black ones, okay.
I'll just listen to it.
And that's 972 is where the judgment starts, Justice Michael.
Oops. Oh, true.
See there?
Yeah.
Right, what paragraph you said?
Yeah, if I can draw the court's attention first to paragraph 19. And the court will see that the applicant in this matter resided in Cape Town, brought the challenge in Cape Town, and the IBC argued that the Western Cape High Court has no jurisdiction to hear the matter because the review was against the decision of the public protector, and the office of the IBC was not situated in the court. And in dealing with this, the court drew a distinction, or it had regard to the wide definition of court in PAJA. And it said that obviously when one's looking at a PAJA review, there's this wide expanded jurisdiction. It said that a review of a decision of the public protector is a legality review. So the wide definition of court doesn't actually find application. And the court said that there would be an incongruency in our law if we had the wide jurisdiction given to a PAJA review and a narrow jurisdiction given to a legality review. And Justices, I make this submission in the context of the legality review that is sought in prayer 1 of the DA's notice of motion. And the court then said that if I could draw the court's attention to paragraph 26 of the judgment, where it referred to the LEC AG judgment, and it said that the decision, one looks at where the decision has impact. And at 26.3, it said in the leading case of Lek, the board's place of business was in Pretoria, but the Cape Division nevertheless had jurisdiction on the basis that the decision taken in Johannesburg adversely affected the legal capacity or right to practice in Cape Town as an estate agent there. And it said, in other words, although the board's decision was taken in Johannesburg, here's the important part, its inhibitory effect, wherever it was pronounced or communicated, hit the respondent in Cape Town, where he was resident and has a business. And it then says that the AD emphasized that convenience and common sense are inter alia valid considerations in determining whether a particular division has jurisdiction to hear a matter in particular courts. And then it went on, and if I could just draw the court's attention to paragraph 26.7, where it dealt with the incongruence between CAJA and a legality review, and the second part of it, where it said, the public protector performs an important constitutional function, and it would appear contrary to the interests of justice, i.e. convenience and common sense, in the language of Lek, to find that persons dissatisfied with her decision would have to bring review proceedings in Pretoria, even if they experience the impact of this decision elsewhere. And the submission is the impact of the reviewing and setting aside of the provincial legislature's mandates is felt at the NCOP, and that is in Cape Town. Justices, I'm going to give you one more reference, which wasn't referred to in our heads argument, but it's a full court decision of this division. And I don't know if I'm pronouncing it correctly, but it's De Gildre versus Sipsey. And the reference is 2024 ZAWCHC 222.
Just repeat that, please, Ms. Pillay.
Sorry?
Just repeat that, please.
I'm sorry, it is in our supplementary bundle as well at page 21, apologies. And if I can draw the court's attention to paragraphs 55 through to 63. And there again, the full court in this division said, at 63, the appellant is a resident in this court's area of jurisdiction, and it is in this court which is easily accessible to him and to which he had to turn to vindicate his rights as the member of the closed corporation, and then deals with common sense and convenience as per law. And so we submit, this court would ultimately ask then, based on these judgments, where is the effect of the provincial mandates issue felt? And it's felt within the jurisdiction of this court, and on that basis I would submit that this court ought to exercise territorial jurisdiction on the matter.
To understand the effect, you mean the actual voting that takes
The
place?
voting that takes place, that's
So when the voting takes place, it's in the NCOP in Cape Town.
that is.
And that decision has not been challenged.
I'm sorry?
That vote has not been challenged.
No, but it doesn't need to be, Justice Saldanha, because the Act is, and I'm going to come to that on the merits of the mandates challenge in a moment, but the short submission is, if the constitutionally prescribed process isn't being followed, then the resultant statute didn't comply with constitutional manner and form requirements, and the Act is unconstitutional as a result of it. But I'll come to that in a
But
moment.
doesn't that then lead to the failing of the NCOP, which takes us to the exclusive jurisdiction of the Constitutional Court.
I'm going to deal with that, Justice Lingers. I say that it's to be grounded in section 65(2) of the Constitution, and I'm coming there. Can I just get through the jurisdiction hurdle for a moment?
Before you do, are we correct in understanding that no relief at all is sought against the NCOP?
No order is sought against the NCOP, that is correct, but a declaratory order invalidating the Act has been sought, that's right.
Well, let's just pause when your convenience and common sense.
Sorry?
Let's just pause with convenience and common sense, which you referred to us in the two judgments. Convenience. The legislature is in Mpumalanga, Northern Cape. That's convenient for the that legislature to step across the road and go to the High Court. Common sense, that's where they should go. How does convenience and common sense help you in this, whether you've come to Cape Town to challenge what had happened or supposedly should have happened in legislatures in 5 other provinces?
So there are 2 legs to it, Justice Saldana. The one leg is the Section 19 challenge, and the second leg is the mandates challenge. And the submission would be on the causa continentia principle. If I demonstrate that I'm in this court on either of those grounds, then it would follow that this court would have jurisdiction on both of those grounds. In relation to the causa continentia principle, how does convenience feature in all of this? The submission is this. The Section 19 challenge, the unconstitutionality of Section 19, is a challenge that's properly brought, I submit, within the jurisdiction of this court. If one were to say, well, I then ought to have challenged the Mpumalanga mandate in Mpumalanga, it would then mean I ought to have challenged the Eastern Cape mandate in the Eastern Cape. I would have had to go into the 3 or 4 different provincial legislative jurisdictions to challenge separately, and I would then be bringing a self-standing challenge to constitutionality of Section 19 in this court. And the consequence of that is it may conceivably be that 5 different divisions are determining the constitutionality of a single statute with a great measure of overlap on the grounds of challenge. Does the Speaker have the requisite authority to confer a mandate of the provincial legislature? So I would submit the issue of common sense and convenience plays out when one looks at what is the consequence of carrying it through in that way. The provincial legislatures say, and I think it's at paragraph 41 of their heads of argument, that they don't expect us to challenge in every single provincial division. If we're in the door in respect of one provincial legislature, then they accept we can be in respect.
Which would have been Gauteng, because then you would have had no difficulty on 19.
Yes. But the difficulty, of course, with this debate is that if for instance, Gauteng wasn't in on it, one would then, if for instance I wasn't challenging the the validity of the mandate from the Gauteng provincial legislature, and so for instance I was challenging KZN, then it raises questions as to which would be the appropriate court when I've got multiple legs of challenge on that.
Continue.
Justices, that's the point in respect of territorial jurisdiction. On exclusive jurisdiction, I'm going to be brief. The first point I'd like to make is that this is not a case about public participation. There are 3 different constitutional provisions that deal with public participation. That is not the DA's case in this matter. The second point is that this court ought not to prematurely close the door on jurisdiction on an exclusive jurisdiction basis. And I say so for the following reasons, Justices. The issue of mandates had become an increasingly prominent feature of litigation that has been attached to public participation challenges. And the Constitutional Court had to grapple with it in the Mohali judgment. And I'm going to just reference the court to paragraph 17 of the Mohali judgment, where Justice Theron said, the applicants concede that there's one issue that's not within the exclusive jurisdiction of this court, and that's the issue of the votes on the mandates issue. And I argued for direct access because it is closely linked to the public participation challenge. The court says it wasn't favoured with full argument and it ultimately left the question open. And I'd ask the court just to have regard to paragraph 17 of Mohali as read with paragraph 58 of Mohali. And the submission is when one looks at exclusive jurisdiction, we know that the court must interpret it narrowly because the Constitutional Court has said so time and time again. I'm going to just quickly give the court the references. In Doctors for Life at paragraphs 13, 19 and 20. In EFF 2016 at paragraph 16 through to 23. And so the submission is there is no clear-cut authority on exclusive jurisdiction in relation to the mandates point. I submit that it is ultimately a legality review as foreshadowed in prayer 1 of the notice of motion, and this court has jurisdiction for reasons I've addressed in relation to that. Justices, let me then go to the merits of the mandates challenge. On the mandates challenge, the first question this court would have to ask is how does the Mandates Act fall to be properly interpreted? And we submit when one looks at the Mandates Act and its proper interpretation, one would have to have regard to the Constitutional Court judgment in Chisuse at paragraph 55, where the court said that the function of a court is to arrive at an interpretation that achieves the most appropriate balance between the parties and that fits most comfortably into the constitutional and statutory framework. And we submit when one has regard to the Mandates Act as read against section 165 of the Constitution, which says in terms that there must be legislation in terms of which provincial legislatures confer authority on their delegations to cast votes on their behalf. And we know that section 42(4) also says that the National Council of Provinces represents the provinces to ensure provincial interests. Now, against that backdrop, Justices, let me ask you to turn to the Mandates Act. It appears in our learned friend's statute bundles at page 36. And it defines a final mandate as a conferral of authority by a provincial legislature. It defines a legislative mandate as a conferral of authority by a provincial legislature. the same in relation to a mandate more broadly. And then importantly, it defines the term provincial legislature with reference to 104 of the Constitution. Again, same for a voting mandate. So when this court looks at whether it's competent for a speaker to confer a mandate, the court would have regard to the express wording of this act, which refers to a provincial legislature conferring the mandate. The court will also note that in Section 3, it deals in terms with the requirements for a final mandate. And it says that at D, it must indicate whether the provincial legislature votes in favour of, against, or abstains from voting on the bill. And the court will ask, can the word vote be substituted to mean at the whim of the speaker?
Sorry?
At the whim of the speaker, the provincial legislature speaker. And the submission, Justice Saldana, is that the Act requires that a mandate be conferred by a provincial legislature. We know in this case the mandates in 4 instances were confirmed by the Speaker.
At the Speaker's whim.
Sorry?
At the whim of the Speaker.
In the absence of any authority by the provincial mandate.
Are you saying at the whim of the Speaker?
I'm sorry?
Are you saying at the whim of the Speaker?
At the behest of the Speaker, let me say that. And so, Justices, when you look at the negotiating mandate, the final mandates, the voting mandates, etc., it refers to the conferral by the provincial legislature. And then when the court looks at the schedule, and our learned friends say, well, it's a schedule, but of course the schedule accords with what the Act contemplates. And the schedule makes reference to a date of deliberation and a reference to the vote of the legislature. And in those circumstances, we would submit that given the proper reading of the Mandates Act, it's not competent for the Speaker to substitute the Speaker for the provincial legislature and for an ex post facto ratification to take place, Justices. And so for those reasons we say, sorry, Justice Saldana.
Sorry?
Oh, sorry, I thought you wanted to say something.
Well, if you want me to say something, I said. And if you want me to say something, the discussion we had about whim and behest is dealt with in the answering affidavits by the different legislatures,
Yes.
where this wide and sweeping statement is made by certain legislators that the Speaker had acted, as you say, at the whim. It was factually incorrect.
Yes.
They had misled this court.
Yes.
And the apology doesn't help them, because they qualified and said it was in good faith. And even more surprising is that the deponent to the founding affidavit doesn't associate herself with the apology.
Justice Saldana, I can't do any better than to say it ought not to have happened. There is an apology, and I apologize to the court for that.
No, but you apologize, but there's no apology by the deponent to what her legislature said. The simple thing would have been was to have fact-checked what they said. To pick up the phone. There's at least 3 or 4 other members who were part of the NCOP delegations. Is this correct, what is being said? But it's not done. There's no explanation why she never fact-checked something as crucial as that. And these 3 other members, they had simply misled this court. The most unceremonious of ways. for an important challenge on this basis. I found it very concerning.
Yes.
But even more so, the fact that the deponent to the founding affidavit, who relied on them, doesn't say, I associate myself with that apology of them misleading the court.
So, Justices, on the question of, so the point is a relatively narrow one on the mandates. It's common cause that the Speaker conferred those mandates. There were, in some instances, they were ratified after the fact, and the DA's submission is they could not have been conferred by the Speaker when the statute makes provision for them to be conferred by the provincial legislature. And we've made submissions as to what the import of this is for the parliamentary processes. Then it's a question that Justice Slingers raised with me, and that is, what is the constitutional hook for the process challenge that has been raised? And Justices, I'll say to you that this isn't a clear-cut case. It isn't clear-cut because it's certainly the first case that I know of where there's a challenge to mandates, but there is no challenge to public participation. And as Justice Theron has told us in Mohali, there are some uncertainties in that regard. But I'm going to frame it this way. The starting point is Section 44 of the Constitution. And there we're told that Parliament consists of the MA and the NCOP, and that they must participate in the legislative process in the manner set out in the Constitution. We're told that the NCOP represents provinces to ensure that the provincial interests are taken into account in the national sphere of government. The second point we make is that Section 65 is an important provision. It's important because it says in 1A, each province has one vote which is cast on behalf of the province by the head of the delegation. So it must follow that there's authority, it must be lawfully cast on behalf of the province. And that's reference to the province and not the Speaker. And it says that there must be at least 5 provinces which vote in favour of the question. And then 65.2, and this is important, admittedly it reflects, it speaks to an act of Parliament that must be adopted, but the important words are in terms of which provincial legislatures confer authority on their delegations to cast votes on their ballot. So Justice Slingers, the submission is, the starting point is that is a competency that under 65.2 rests with the provincial legislatures to confer that authority. And then, members of the court, if I can draw your attention to Section 76 of the Constitution, which says that in 76(1)(a), it must be passed by the NCOP because it was passed as a Section 76 a bill, and the submission is it can't be said to be passed by the NCOP if there's no agreement by 5 provinces as is required by Section 65(1). So for those reasons, the submission is that there is in fact a constitutional hook. The constitutional hook isn't a single provision that opens and closes it, but the provision is Section 44 read together with 65, read together with 76, as together with the Mandates Act.
So, Ms. Pillay, we're going to hear argument about sections 116.
Yes.
Do you want to talk to us about that,
Yes.
please?
And the submission is, of course, their internal rulemaking powers that various bodies have. but those rulemaking powers can never be such that they override what the constitutional imperative is. And the submission is under 65(2), the constitutional imperative is for the provincial legislature to confer the mandate.
How it confers is what they say 116 deals with.
Yes, yes. And the submission is when one looks at what the role is of the provincial legislatures to bring the voices of the provinces, we've put it in our heads of argument with reference to Doctors for Life and those other cases, what the role is of the provincial legislatures. The question of how can't be answered by saying a substitution for provincial legislature with speaker of a provincial legislature in circumstances where there's no deliberations, there's no voting on it, and it's the speaker...
Sorry, there's no deliberations where?
Sorry, prior to the mandate being conferred.
But there's deliberations in the select committee.
Yes, I'm sorry, I'm talking about deliberations by the provincial legislatures.
Yes, but there is deliberation, because the select committee is an integral part of the provincial legislature.
Yes. So there are three steps at which it happens: the negotiating mandate,
Yes.
the final mandate, and the voting mandate. We have the committee that engages at the first stage, which is the negotiating mandate. We have the provincial legislature, which is seized with conferring the authority at the latter two stages. And that's made clear in the Mandates Act. And so the submission is when a speaker confers, whether it's a final mandate or whether it's a voting mandate, when she does so without that having come from the provincial legislature prior to the conferral, she doesn't have the competence to do so. And if the court is to find that, well, if the rules give her that competence, then I'd have to accept that that's the result of it. And then the DA's challenge becomes even narrower, and that is the question of whether there was compliance with the rules.
So you're not challenging the rules. If we find that it's compliant with the rules, that's the end of it for you on that.
So we have, of course, put in a belts and braces challenge to the rules, but we've said it's not strictly necessary because we've referred the court to the Constitutional Court judgment in Fetsas and the Ambrosini judgment and those cases.
But you've got to tell us if that challenge is still alive or not. We can't be sniffing as to see whether it's alive or not, quite frankly. Tell us whether it's alive or not.
Just hold on and let me take an instruction.
Because the other side would need to be able to know what and how to respond to it.
Yes. We've made very little of it in the heads.
My impression was that challenge to the rules had been abolished.
Yeah.
And that
I
it was
was
no
just-
longer proceeding.
I was just going to say, Justice Lingers, it's not dealt with in the heads of argument at all, and so I can't take it any further than that. It's not been pursued. I will like to confirm that, but yes.
No, it wasn't just not pursued. There was a positive statement that you're no longer proceeding with that challenge.
I'll double check.
At least
Justice.
on my recollection.
Okay. I will check in the vote report on that. Yes. So just on the, and I'm conscious of time, so let me, but I would have to accept that if the court finds that it has competently been dealt with and could competently be dealt with in the rules, then the only remaining issue is whether or not there has in fact been compliance with the rules. Those are my submissions. I would like to have the benefit of 5 minutes after the lunch adjournment.
So you're not going to deal with whether there's been compliance with the rules, because they say in your reply you begin to change the basis
Yes.
on which the challenge is made.
We've made the submissions in our written heads
Yes.
on whether or not there's been, and we submit there hasn't been compliance. Let me get the court the
We've read it, it's fine, we've read it. Do you want to comment on that? Because the one issue is whether there's been conference with the political leaders.
yes.
Surely you want us to strike down an entire piece of legislation because of conference with the heads of the political parties?
Well, I mean, the difficulty is that the challenges in relation to compliance with the rules are few. With regard to the Eastern Cape, the question is whether or not the exigencies of the situation called for a conferral of a mandate by the Speaker.
Just remind us, so the Eastern Cape was when it was dealt with in the afternoon.
Correct.
And so they sat in the morning, in the afternoon the committee sat. That's a factual issue.
Yes, and the
It wasn't dealt with in the morning. The committee dealt with it in the afternoon.
But there's a different issue at the Eastern Cape. It's the wrong version of the bill.
The number,
Yes.
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 You know, really, 490 people can't see 19. But really,
The point's been made.
it's the
Justice.
substance, it's form over substance.
Yes.
Is that what you're submitting to us?
I'm not submitting that it's form over substance. I am submitting that the first point is, can the rules override the statute? If the court says yes, it can, then the second point is, was there compliance with the rules? And I don't want to be seen to be taking technical points, but the rules do provide in these terms, and the submission is that there's non-compliance with the rules. Whether the court reaches a conclusion that says there was non-compliance, but it wasn't material enough for the court to strike it down.
What does the applicant say?
The applicant
Is it the
says
material
that
non-compliance?
That it was the cumulative effect.
You know, in respect of Eastern Cape,
Yes,
with the wrong number,
yes.
is it a material non-compliance?
Well, when one looks at it, and I'm not ducking your question, Justice Saldana, but
I'm not saying you do.
Not at all. I'm submitting that if that were the only ground of challenge,
By the Eastern Cape.
yes, it may well be an issue that this court can legitimately find
So-
is not material.
Besides the deferment to the Speaker,
Yes.
this one aspect of the incorrect number on the bill, you said that becomes significant?
I say that there's also the issue of the Speaker having failed to consult with the party leaders before conferring the final mandate. And she admits that she failed.
And none of the party leaders come and say, we were not consulted, but we sat when there was ratification. We sat in the House and we voted. How does that happen? So they come and complain and say there's been no ratification, our unhappiness is not recorded, but they vote. Or maybe they abstain because we don't have the numbers. But there's no indication that any of them in the legislatures, when it came to ratification, had raised their hands and said, we object, as opposed to voting against. We object to the process. How does that happen, Ms. Pillay?
I would submit that even if that does happen, it doesn't preclude a challenge on this basis, Justice Saldana. Of course, it would be one of the considerations that the court would weigh in on in considering the merits of the challenge. But it certainly doesn't constitute a basis on which to say, well, the challenge doesn't get off the starting blocks.
Well, you know what? You sit in the legislature, there is a vote for ratification, and I assume that the applicant was represented in that legislature when the rules were drafted.
I'm not.
No, I'm so, well, or up until this act, there was no single objection where they say historically we've always objected to the Speaker having the power to ratify. Never said that to us. They've been participating in these legislatures, they've been ratifying and they've just been quiet.
Yes.
Quiet, and then when the challenge comes and says, you can't ratify.
So, Justice Saldana, if the point is a good one, it matters not what the historical position was. The submission is, if it's not permitted under the constitutional and statutory framework, the fact that it has historically occurred doesn't give it validity.
No, I accept that. But they don't explain their historical acquiescence.
Yeah.
All of them, where the challenge is made from.
Yeah.
You know what it sounds like?
I'm going to go. Yes. So that is a position in relation to the Eastern Cape. The court has seen the difficulties in relation to Gauteng. I've raised...
Gauteng, the report was tabled. The report of the select committee.
Yes.
Unanimously accepted, except for the DA having raised its reservations, and a separate report was filed on that.
Yes, and the point is simply that the report was adopted ex post facto as opposed to the final mandate having been confirmed.
Well, notionally, ratification would happen ex post facto. That's the nature of ratification.
But Justice Saldana, the point is, I think this, not I think, I submit this, and that is there's an important role that provincial legislatures play in the lawmaking process. There's an important link between that role of the provincial legislatures in the lawmaking process and the process before the NCLP. The link between those is a duly authorized mandate on it. And if that mandate comes from a speaker which is subsequently ratified, what it does is it means that there's a process occurring at the stage of the NCLP which hasn't properly run its course at the provincial legislatures. And that, the submission is, undermines the voices of the provincial legislature.
And the voices of the people in the province.
Maybe.
You're nodding.
It may be, but I understand where the point's going, and I want
You know where the point's going,
Yes,
because
and
there's been extensive public participation in all of the regions, and even at the national level.
Yes.
So there has been public participation on the
Absolutely
Act.
right. Yeah.
People have had their voices, people have gone into the extensive rural areas, and they've consulted. So the one thing cannot be said about this matter is that there's been no consultation,
Yes, yes.
and the voices have not been heard.
No, we're in agreement. This isn't a public participation challenge.
But the voices were heard, they were taken back to the provincial parliaments, and the select committees dealt very meticulously with the issues that came out of the public participation. In one of the provinces, they raised extensively
Yeah, 19.
what the concerns were. I think it was 19.
Yeah.
Those 19 concerns were taken to the NCOP in the committee. There's no indication that the concerns raised by people at an ordinary level had not been taken into account, and even those by the various political parties had not been reflected in the debates of the NCOP Select Committee. It's not a failure of democracy in this process, in this one, where you have challenges dealing with non-consultation, where there's a failure of democracy. And so I raised that with you because you raised the issue about the voice of the provinces.
Yes.
The voice of the provinces took place at an extensive level in consultation,
Yes.
public consultations.
Justice Saldana, I see it slightly differently, and that is there is a consultative process where there's no issue that the DO takes with that consultation process. There is then a conferral of authority process, and that is distinct from the consultation process. The law requires that that conferral of authority takes place in a particular way, and the submission is it didn't take place in the way contended for. And yeah, you've raised the detail around it. Justices, those are my submissions. May I ask one small
Certainly.
indulgence, and that is, can I have 5 minutes when we come back? I know I've been on my feet for a very long time. I
Certainly.
give the court a solemn undertaking. It won't be longer than 5 minutes, Justice. Thank you.
Just, it's 1:05, and so we're into lunchtime, so we'll come back at 2:15, everybody.
Thank you.
Good. Thank you. We'll adjourn.
Indulgence. Justices, I'd like to just close off on 2 issues. The first is the question of the challenge to the rules. And Justice Slingers, just to perhaps make it clear, our position is as set out in our heads of argument. There's no abandonment of that challenge, and if I may direct the court's attention to 018-47.
08.
018-47, Justice Michael Lockwood. And the principal point is that in terms of the Constitution and the Mandating Act, that's a power that ought to be conferred by the provincial legislatures. To the extent that the rules allow for that, they're unlawful. The DA says it doesn't have to independently challenge those rules, but if that's going to be what stands in its way of getting its orders in prayer 1 of the notice of motion, then it does challenge it. And it's paragraph 105 which deals with it in some detail. Members of the court, if I could then just close with asking you to go to, if you don't mind, the notice of motion in the matter, 001424. And prayer 1, of course, is the legality review of the final mandates that have been challenged there. And the submission there is that based on the effect of those mandates, this court has jurisdiction to determine that challenge. It's a straight-on legality challenge, and the submission is that an order in the terms sought in respect of those provincial legislatures that we've persisted with ought to be granted. The second order is, of course, the order that the Act itself is invalid, and for reasons that I've submitted, we say that given that the Act hasn't come into operation, there's no interim state of affairs that needs to be dealt with. The effect of any ruling order is final in effect, and given the different permutations of what may be done, they properly lie as legislative choices to be made on that. Thirdly, we challenge the rules on the limited basis that we've set out in prayer 3. And finally, in the event that the court is not with us, that a Section 19 challenge constitutes a challenge to the results in a challenge to the Act in its entirety. In the alternative, it's the Section 19 in the term sought. Justices, those are my submissions, unless there are any further questions.
Thank you, Ms.
I'm
Moran.
indebted to the court. Thank you very much.
Good. Who goes next? Is it?
Judge, we've agreed between ourselves and AfriForum that we will go first. And they will hear which questions you ask, and they will then deal with those.
Smart of them. Good.
You can also do it the other way around, of course. If they were first in time, that's what we thought they should go second.
Very well. Thank you.
Yes, we issue first in time. That's the reason. Justices, I'm going to not repeat any of the arguments that my friend Ms. Pillay made. Some of those arguments deal with points that we have made in our papers and in our argument as well. And in that regard, where the arguments overlap, we make common cause with what the DA has submitted. That would go, for instance, to the point of jurisdiction, although jurisdiction has not been challenged in our papers. But insofar as it may be relevant, we follow the DA approach. And then in respect of the attack on sections 19(1), 2 and 3, we also follow the DA's argument. And our submission is that in the light of all the different possibilities of reading in that have been put to this court, we believe that it should be referred back to court, and that there should be no reading in. We have in our heads of argument very shortly dealt with the legal principles of reading in, and specifically the reasons why reading in is not the appropriate remedy. What I want to get to is section 12. That is the gist of our attack on this act. And you would have seen in our heads of argument, and I think more than 50% of our heads of argument we spent on the international law. And the reason for that is the following. What we have tried to set out in our heads of argument is exactly what is customary international law insofar as the right to property is concerned. And we submit that we've made out a case that the right to property, even though it is not specifically recorded in our Constitution, forms part of customary international law and therefore forms part of the South African law. In respect of the question of compensation that goes with the right to property and expropriation, we've also made out a case that compensation in very, very, very rare circumstances will be regarded as null in the international law. We have not been able to find a case, although there may be, I must concede, where no compensation has been granted. The courts have, however, in especially the European Court of Human Rights, said that full market compensation does not necessarily follow. And the courts have also mentioned that much lower compensation could be granted under specific circumstances, and there are in fact cases where this happened. Of particular importance in respect of international law, we submit, is what the SADC tribunal said in the Campbell case, which we quote extensively in our heads of argument, and also what the Zambian Supreme Court, most recently, about a year or two ago, said pertaining to expropriation and compensation. Those decisions indicate the direction of thought to the question of compensation in the southern part of Africa. We therefore submit that in the light of the comprehensive discussion of the international law that we have provided you, which I'm not going to go through, the following conclusions can be made. Firstly, that even though in section 25 no right to property is specifically protected, that is protected in terms of the international common law. And then compensation is paid and granted in most cases. In Europe specifically, they have indicated that it may be less than market value. In the Americas, some of the arbitrations and court cases that we've referred to, it's mostly market value related. And that, Justices, is what Section 25 says. Section 25, except for the right to property, has been formulated specifically with reference to the international law. Section 25.2 is very clear in our submission. It says property may be expropriated only in terms of law of general application for a public purpose or in a public interest, and I pause there, and then it says, and subject to compensation. It does not say subject to nothing, no compensation. It says subject to compensation, the amount of which, so there must be an amount, and the time and manner of payment of which, so there must be a payment. You can't pay no rand, I submit, of which have either been agreed to by those affected or decided or approved by a court. That is what the Constitution says, and that is what the international law says. The moment one accepts that, it means that any possibility of no compensation is not arguable. It cannot be rectified through normal legislation. It cannot be changed by normal legislation because of the fact that the Constitution is paramount. Constitutional supremacy is the first and foremost principle of interpretation of laws pertaining to constitutional issues. Then in section 25.3, the Constitution says the amount of the compensation and the time and manner of payment. And I emphasize that because that part of section 25.3 one does not find in section 12 of the Expropriation Act. Must be just and equitable, reflecting an equitable balance between the public interest and the interests of those affected. Many cases, in our argument, have said that that's the international principle, that's applicable internationally, that's how it is looked at. It is the proportionality principle that they talk about internationally. Having regard to all circumstances, including, and then it sets out a list of 5 principles, including the market value of the property. The market value is not raised as the most important factor to take into account. Then it says, section 25.4, for purposes of this section, the public interest includes the nation's commitment to land reform, and B, property is not limited to land. Now, if we just stop there, a court that has to deal with this section without section 12 of the Expropriation Act has to make a decision based on a wide discretion, not a narrow discretion. This is a wide discretion that is given to the court, taking into account 5 factors laid down in the Constitution. If we then turn to section 12 of the Expropriation Act, we see in section 12.1 that the time and manner of payment has been taken out of this section. It is a repetition of section 25.3 of the Constitution, but the time and manner of payment is taken out, so it doesn't follow the Constitution. It only says the amount of compensation must be just and equitable, reflecting an equitable balance international law, between the public interest, the interests of those affected, including an owner, holder of a right, a mortgagee, having regard to all the relevant circumstances. That's still the international law. Including, and then it gives the 5 principles. What the reason is for the repetition of section 25.3 is not clear, and why the words the time and manner of payment has been taken out of section 12 is not clear. But it is inconsistent with the Constitution. Section 12 as it stands there, 12.1, is because of that inconsistent with the Constitution. Then we get to sections 12.2 and 12.3. And 12.2 sets out what the court now must not take into account, unless there are special circumstances. So now a court that has to consider those 5 constitutional principles have another 6 to consider. And then in section 12.3, says it may be just and equitable for no compensation to be paid where land is expropriated in the public interest, having regard to all the circumstances. That's contrary to section 25. And what section 25 says? 25.2. That's inconsistent with the Constitution. And then it says, including but not limited to, and it gives 4 examples. So now a court that has to consider expropriation has 5 constitutional principles which must be weighed in this wide discretion consideration. It has 6 considerations that it must not consider, and it has another 4 that it must consider. What does the court do? Does the court give more weight to those principles set out in section 25 of the Constitution, because they are in the Constitution, as opposed to what is in section 12.2 and 12.3? Which of these principles can or could be an overriding principle? And that is the fundamental problem we have, apart from the fact that this is all inconsistent with the Constitution. That is the paramount important problem we have, is that the court is now forced to take into account principles when it considers relevant circumstances which were not in the Constitution and which are contrary to what agreement was reached in Kempton Park in the negotiations pertaining to the wording of section 25. It is not without reason that section 25 says, and subject to compensation. It was one of the most debated parts of the negotiations at that time, and I'm luckily old enough to remember that, although I'm not testifying from the bar. But it was a hugely debated issue. And the first certification case of the Constitution made it very clear that the interpretation is that it is subject to compensation. We refer in our heads of argument to that point. Now, section 12.2 sets out the principles which may not be taken into account. And some of them, I must say, are principles that the court will not take into account in any event. such as improvements made after the date of the notice of expropriation. But some of those principles are already entrenched in our law of expropriation under the old Act, the 1975 Act. The fact that the property has been taken without the consent of the owner or holder of the right. There is authority for, I don't want to say each, but for probably, as far as I know, this part of the law, each of those principles, where the courts previously took some of these issues into account. The enhancement or depreciation of the value of the property in question after the notice of expropriation. There's law, lots of law, lots of cases. What's it doing here? Why must we have this legislation when we have the law already? In fact, we have one case, Muslavati versus Frick, where the court under the new constitution granted no compensation, which we submit was wrong. It's contrary to the constitution, it's contrary to section 25, 2 of the constitution. But there is that one case. There is in our heads of argument a reference to Professor van der Walt, who says, yes, maybe there may be no. We try to look for other arguments about no compensation, and when you look through our bundle of authorities, which I'm not going to go to during this talk, we have given you probably everything that has been published on the arguments about no compensation in South Africa. You'll find it all there. There is some criticism on section 12.3, apart from the fact that it's inconsistent with the Constitution. And I want to deal with that now. Section 12.3a says there can be no compensation where the land is not being used and the owner's main purpose is not to develop the land or use it to generate income, but to benefit from appreciation of its market value. This is directly focused upon developments. It's people who go in Cape Town, north of the northern suburbs, who see that there will be further development there. You buy one of those expensive farms at today's price, hold it, don't do anything with the property, with the view that there will come some developer who will pay 10 times the price that it paid. That is a direct interference with the property market. It is a direct interference with the capitalist approach of the right to property. Because right to property, whether you want to know it or not, is a capitalist principle. It is one of the principles underlying capitalism. The easiest way to get around this provision, obviously, if you buy that property in the northern suburbs, but you decide you're going to keep a few horses there and sell and buy horses, then you're using the land, then you get past that provision. So the provision is actually not rational, makes no rational sense.
Mr. Duplessis, isn't your approach focusing on a single factor and only dealing with a single factor asked in section 12.3a? Should you not, in terms of interpretation of the principles and approach, deal with it holistically? It is but one factor that the expropriating authority may take into account.
That's my intention. That's my intention to deal with it on that basis. But But let's say, for instance, you're faced with this expropriation as a court. You are now faced with this expropriation and the example that I've given. And you look at the act and you look at it and you see, oh, that there may be no compensation, and the one party argues there should be no compensation, then obviously you're going to give attention to that. I'm not saying you're going to lift it up to the most important principle, because that's where the problem comes in. Do you lift that higher than the principles in the Constitution? Is it equal? Which ones play the biggest role?
Isn't it? You take a holistic view of all the factors that's
Yes.
presented and the facts and the circumstances. And you
Yes.
look at the objective that the legislation wants to achieve, as well as the spirit and objects and purpose of the Constitution.
If you take into account the spirits and object of the Constitution, you can't pay less than nil. There's nothing that stops you to pay less than nil compensation.
Sorry, less than?
There's nothing that stops a court to award less than market value. I'm sorry, less than market
Just
value.
the first time I heard less than null.
Less than no, I'm not going so far. I'm not going so far. Less than market. So the fact of the matter is that there is difficulty with that. The second one, where an organ of state holds land that is not using for its core functions, is reasonably likely to require the land for its future activities in that regard, and the organ of state acquired the land for no consideration. It may be, and that's the one example that we raised, that you eventually get two organs of state fighting about property, because property forms part of the balance sheet, forms part of a municipality's balance sheet according to which they lend money. And you may run into that kind of problem. But again, it is not a reason to determine that there must be no compensation. It may be a reason for lesser compensation than market. Notwithstanding registration of ownership in terms of the deeds registries, where an owner has abandoned the land by failing to exercise control over it despite being reasonably capable of doing so. This is really a difficult provision. Because firstly, what does abandonment mean? And I read in the documents, and you'll read in our bundle, that an example that is used is a family that, and these are real facts, a family that immigrated to Australia. And they had about 12,000 hectares of land in the Eastern Cape. And I don't know who I don't know all the facts, but I don't know who they left to care for the land. But they did absolutely nothing on it. Absolutely nothing. They just left. So that is the idea, is when there is such an abandoned property or an abandoned building in Hillbrow in Johannesburg, where the property owner doesn't pay property rates in it, that there is a justification for lower compensation. And
Just for practical,
sorry, Joe.
what is commonly referred to as hijacking of buildings, is
Correct.
that right?
Correct, yes.
Owner doesn't lose control over the building. All the owner has lost is effectively somebody else has taken possession, but it's still their property. And sometimes they may go to court, or sometimes they are almost helpless because the hijackers, whoever they are, effectively take control of collecting the rents, and they hardly pay any rates. Doesn't necessarily mean that the owner has lost control.
Or
Because
abandoned.
abandoned, because it's beyond the hands of the owner.
Correct. And
By unlawful activity, and also very often
Yeah.
by violence.
one of the arguments could be that as long as my name is in the deeds registry, as the owner of this building, I haven't abandoned it. The problem is with the interpretation of abandonment. And that's why we submit, why put it in here? Why is it necessary to be in this legislation? Those are factors which any court, any one of the three justices who sit here, will consider when an expropriation argument is made before.
So why is it unconstitutional to put it in the act? If it's factors that any of us sitting here or any court will take into account when faced with a decision of determining a just and equitable compensation, why
Correct.
is it then unconstitutional to put it in an act?
Because it says, in these circumstances, you may pay no.
Yes,
That's
may
the reason.
pay no. Doesn't mean to say you will or you must pay no.
No, but it's
That's one of
unnecessary.
the arguments, I think, from one of the respondents as well as the amici from the respondents.
Yeah.
That it allows, it may be the outcome, but it's not a definitive outcome, that will be the conclusion.
What's the reason for that? Why should there be a reference to no compensation in the Act? Because the problem is that just opens the door for, in 5 years' time, a further list of categories to be added to this. It's not necessary, and it is unconstitutional to add to what was said in Section 25. And the submission that I'm making to you is, it's not going to affect anybody if Section 12 is taken away.
It is not constitutional if it's in, but there's no effect.
But it makes provision for no compensation. If you take out the no compensation and you read just, it may be just and equitable for compensation to be paid, for some compensation to be paid where land is expropriated in the public interest, or lesser compensation than market value, something like that. The point we're trying to make is that this is going to make life for the courts difficult, and it is unconstitutional. Let's just start there. It's unconstitutional. What I'm doing now is I'm just pointing out to you the difficulties that may arise should this go through, and should this apply, and should a judge have to face these principles. And then where the market value of the land is equivalent to or less than the present value of direct state investment or subsidy in the acquisition and beneficial capital improvement of the land. Now, we all know how much money the government has spent on purchasing land for beneficiaries in land claims. If you have unscrupulous government employees, you may end up with a situation that expropriation might take place for no compensation of their property. Because that is the best example of state investment into a property that is given to another. Again, it is going to cause the courts difficulties, because what happens if you get a case like that? What do? Do you then say, well, when it comes to null compensation, these 4 factors must be taken into account first. So I take that into account, and that is worth much more. And I value that much more than what is said in the Constitution. And therefore I'm going to apply it, and I'm going to say there's no compensation. The courts don't need to, or want to, or should be getting into this one.
Could I raise a theme with you? And that is the notion to make determinations on what could be unscrupulous, corrupt, dishonest officials of the state. Now, we can't determine constitutionality of legislation on the basis that there may or there will be unscrupulous
No, for
state
sure.
officials.
I'm just trying to give examples of difficulties should this legislation remain standing and not be found to be unconstitutional because of the main argument about what Section 25 says. If it remains standing, these are the difficulties that are going to arise when the courts have to consider this. And another problem is the purpose. And we filed additional heads of argument, which I'm not going to go into much, It relies on the impact assessment study that was done before this act. But one of the examples that we raise in our aids of argument is that if a person, a property owner that has lots of properties, makes a loss with a no compensation award, that loss can be written off eventually against the capital
Gains.
property tax that is levied upon him on the sale of another property. So it is not as if you now pay no compensation and therefore the state scores because the state doesn't have to pay any compensation. Because there are all sorts of other ramifications on a no compensation approach that may eventually turn out not to benefit the state so much financially as was thought with the insertion and the arguments pertaining to inserting or promulgating this legislation. So we have, I'm not going to repeat my example. We have given you the examples of what may happen. Not all of them. There are lots of others which I thought about, but I'm not going to waste the cost. There are lots of difficulties that will arise from, but you don't have to go there, because all you have to do is to find that legislation is contrary to section 25(2)(b) of the Constitution, inconsistent with it. And section 172(1)(b) follows, and we say, we submit that it should be set aside on that basis, either the whole Act or at least sections 12 and sections 19. But you have so many problems arising out of section 19 that we submit that it is the whole Act that should be set aside and be dealt with right from the start. And it would be a good idea that the people who sit in Parliament, the 490 people who you referred to,
On a good day.
on a good day, get some advice from somebody who's done legal research into the international law. Because our section 25 is wonderfully written in accordance with the international law. And
Mr.
South
Duplessis,
Africa should not, sorry.
Yes. Can we just talk? Thank you very much for the extensive excursus on the international law. It really was fascinating. But we've heard everybody else also on international law, and there's a dissensus as to exactly what international law says. And so we would have to distill with all of it as to what exactly international customary law is in the circumstances of the property, and what are the various permutations which apply. Because there's no consensus amongst yourselves here.
No, for sure.
It's almost like the United Nations.
It is.
As to what the law is. So, just to acknowledge for that extensive elaboration on international law, what does come across very clearly is that there's a grey area in international law on these very issues.
Lord,
Just judge.
Justice, there's the old thing. 36 years, I'm sorry. In our bundle of authorities that we've given are extensive discussions, which we could recall about what is customary international property law and what is not. And you will really find benefit from going through some of those articles that have been written by eminent scholars about what is customary international law, because you have to draw a distinction between what is international law that you can look at in terms of the Constitution and consider, and what is really customary international law. And we have set out in our heads of argument specifically, the reason why we say the right to property is customary international law, because it is enshrined in the Universal Declaration of Human Rights. It's enshrined in the African Protocol on the African Charter of Human Rights. It's enshrined in a huge number of treaties.
Two important conventions don't enshrine
The two
civil and political rights and
Correct.
socio-economic.
Correct.
Is that not significant?
Pardon, Justin?
Is that not significant?
That is significant, and I really wondered about that and
Well-
couldn't understand why that was not there. But if you look at the rest of the law surrounding those two conventions, one can come to the conclusion that the right of property is customary international law in South Africa.
Well, especially the Convention on Socio-Economic Rights, because that's the one that really deals with issues of
Correct.
property, but it doesn't. And we'll hear what the debates are for those who have looked at it more carefully and
Yeah.
more clearly as to what the considerations were.
The European Convention also does not make a provision for it, but found that it was in fact on a conspectus of international law, a customary international law right, and also gave judgments, which we've got, on that issue of what is customary international law. But to come back to the gist of the argument, you could write a one-page job.
One page.
One-page job, referring to section 25 2b.
It says unconstitutional and unnecessary.
Correct. And that's the end of it. And that's my job, is to persuade you that you
To the
don't have to
one-page
work
judgment.
hard. You don't have to spend so much time on this case.
But we've got to read all of it international law you put before us.
Lord, and that really sums up our argument. I'm not going to refer to any further detail in our argument. We submit that for purposes of costs, the normal Firewatch principle should apply, and therefore we submit that we've already been successful in the challenge in respect of section 19(1), 2, and 3, and that we should get costs of the application.
Just to take you back just for a second, there's going to be much debate over the next couple of days with regards to the different conceptual approaches to sections 25, 25.2 and 25.3. That's going to be the rigorous debate that parties are going to put before us. It's a conceptual approach to it, and there are different conceptual approaches to how one resolves or reconciles those two sections. Do you want to make any comment on that before you sit down?
I'll deal with that in reply.
Okay.
We will be here, we will be listening very, very finely to arguments on that, but we will deal with that in reply, whatever is necessary to deal with,
Very well. Thank you.
as it is.
Mr. Wenger, are you ready?
Thank you. I indeed ready. You must perceive that I will finish my argument with the little time that we have left. By now we're all a little punch drunk after the morning of debate.
Blame Ms. Pillay for that.
We have to listen. Judges, keeping in mind the directive that was given, I thought of ways to compress the argument on behalf of AfriForum into an hour, and it can be done if some important issues are going to be missed. So what I propose, subject to your confirmation, and I will not take days to finalise the argument, is that I give as a short opening statement in regard to the 10-minute issue, the overview of what AfriForum's case is, and then return to the structure of the heads of argument on the important issues. It makes it a little easier and for us, and also allows us to save some time, is that we have a second applicant who specifically addresses parts of section 12, well, the whole of section 12, but in more detail. My intention is to concentrate on the principles and answer the question that Christine has asked. Why is section 12.3 unconstitutional? And that goes, of course, to section 12.4, in respect of which my argument is going to be really short. In respect of the challenge to section 19.8, that is the appeal procedure, if you allow me, I would request that my Linda Junior give at the appropriate time a short address on that, and then I will return at the end of my address to Linda. Starting with the opening statement, AfriForum challenges the constitutionality of certain of the provisions of this Act. It started off as a challenge to the whole Act. We no longer persist in that. This is not a challenge, let me make it clear right from the outset, it is not a challenge to land reform. Land reform is a constitutional imperative. It is an obligation of the nation that we all have. Section 25 of the Constitution itself records that commitment of the nation to land reform and to equitable access to land, tenure reform, to restitution. And there are already a number of land reform statutes dealing exactly with that. More is probably needed. AfriForum's case does not ask this court to address, to arrest that process of the land reform program. He asked the court to preserve the constitutional method by which expropriations, including expropriations in the public interest, may be carried out. The challenge to the sections that we wish or request the court to be severed from the Act and declared invalid are sections 12 sub 3, 12 sub 4, which provide for no compensation, and this is the main focus of AfriForum's challenge, as well as section 19.8, which protects the property rights of every citizen in this country. Of course, there is the challenge to section 19.2 and 3. That challenge has largely been submitted by the respondents, calling it a drafting error by Parliament. I will deal very shortly with that. I will return for the DA has already addressed you fully on that. Section 25 of the Constitution contains both provisions that protect property rights and provisions that make provision for restoring and correcting historical wrongs, which resulted in imbalances in property art. We all know that, and that's why we have section 25 of the Constitution. And I agree with my learned friend who's just argued that section 25, as a result of the intensive negotiations, is a well-written section in our Constitution. So the immediate question is, how is this imperative of land reform addressed within the context of expropriation? And I ask this question right up front because many of our opponents who support the Act see as the main aim of this Act to make it easier to effect land reform. And that's why I'm asking the question, why is, how is this problem, this obligation on the nation to land reform addressed within expropriation context? The answer in our submission is this. In its classic form, expropriation is the taking by the state of private property and then using that private property for public purposes. Building of dams, buildings of hospital, roads, etc. The expropriator, that is the state or one of the expropriating authorities, becomes the owner of the property which it then uses for the public good. this is an original form of expropriation. We've referred you to the case law, and it's all trite expropriation law, which is not going to be amended or changed by this act. But, as they say, taking from Peter to give to Paul is not typically an expropriation, because the state doesn't become the owner. It takes property from one person and gives it to the other. This is, however, now made possible in Section 25 of the Constitution by providing for expropriation in the public interest. And public interest, by definition, includes the nation's commitment to land reform. That means that the state is now allowed to expropriate, not for itself, but for the transfer of property to a third person who is entitled to land reform. But not only land reform, also other public interest purposes. But land reform is such an important topic within the context of this case that I refer to that in that respect. There are already several land reform statutes that specifically make provision for expropriations for land reform purposes. Those statutes are post-1994 and 1996 Constitution statutes. They all say that expropriations are subject to compensation. And how compensation is to be determined is with reference to Section 25(3) of the Constitution, which lists a number of factors, open-ended, but in the end has the obligation on the state to pay compensation that is just and equitable, taking into account all the balances of the parties affected. The Expropriation Act of 1975 is still in operation, and to date it has been used on occasion post-1996 for expropriations, but the courts found no difficulty in interpreting that act to be in line with the Constitution. So we already have a number of cases where the court, up to the Constitutional Court, has determined compensation based on the clause contained in Section 25 of the Constitution. That the need for a new Expropriation Act for our country is acknowledged by everyone, and that is why the Act is necessary, and the Act contains much that is good. We are concentrating on those sections that we say are unconstitutional, and which is a vice and will not have the effect that we wish with an Expropriation Act that complies with the Constitution. Our submission is that the sections that we specifically attack do not comply with the Constitution. An important point is that severing sections 12.3 and 12.4 of the Expropriation Act will not hinder land reform. It will not affect the position of the state to expropriate properties. It will not defeat any of the aims of the Constitution. The new Act, without these offending sections, will allow expropriating authorities to expropriate property in the public interest without infringing constitutional rights. And that is what we are concerned with. Section 25 of the Constitution legal permits expropriation for public purpose and expropriation in the public interest to be both. It expressly includes land reform within the public interest. It also says that expropriation must be subject to compensation. For that reason, AfriForum is another case accordingly, and it does not persist in the challenge to the other here. The first point in respect of the challenge to Section 12.3 and 4 is this. These provisions are defended by some of our opponents, and also by some of the commentary who do not support our case, to say that these are merely harmless guidelines to a court or to an expropriating authority. The compensation regime in Section 25 of the Constitution does not distinguish between expropriations for public purpose and expropriation for public interest. Section 25(3), which deals with the requirement of just and equitable compensation, is the same for all expropriations. Section 12(3) and 4 of the Act changes that, puts a different complexity, reflection on it. It is an amendment of Section 25(3) of the Constitution, by allowing a list of no compensation cases. The Constitution does not contain a list of no compensation cases. But Section 12(3) creates one. It does so in respect of the land and for expropriations in the public interest, not expropriations for public purposes. And then it leaves it open-ended. I know my colleagues for the President Steve argued that's a good thing. It worsens the whole situation. Instead of just a list of 4, which then can easily be dealt with by an expropriating authority report, now it leaves it open, saying not limited to. That aggravates what we submit is an infringement of the rights in Section 25(3) of the Constitution to compensation. And that matters in practice, and that is what I wanted to say in the opening address. Property rights protected by Section 25 of the Constitution are not limited to registered rights. They include unregistered rights. We now know from the recent Court judgment that it includes incorporeal rights. It includes the rights of millions of our citizens in rural areas who live under customary law. Those rights are affected by this. This is not a protection for a class. It's for every person whose property may be taken by the state. The Act will not be administered by a single idealized expropriating authority with high morals. There are many expropriating authorities out there, including some really struggling local authorities with little capacity, problems of their own. There's very uneven administrative capacity out there, and the estimate is that there is about 400 expropriating authorities who will use this Act to deal with expropriations within their areas of jurisdiction. Respondents say this concern that an expropriating authority, which now gives guidance, as they say, from Section 12(3), the assurance is the court is the final arbitrator. In practice, that is no consolation to the majority of landowners out there, or not landowners, property owners, because it goes much further in the land. It's no consolation to the majority of property owners. We all know that in some divisions of the High Court, taking a case to court now takes years before you get a trial there. Litigation about valuation and just and equitable compensation is difficult, it's technical, it's time-consuming, it's expensive. We have referred in our bundle of authorities, for example, to the well-known Dawn case. It's on the L in our bundle. When that judgment was written, it was just on the point, technical point taken by one of the parties, saying that the evidence of particular value should be disallowed because it amounts to hearsay. And the judgment of the court in that case dealt only with that aspect. first paragraph of the case reports that this case is now in its 6 months on trial. It was only halfway through. We've referred the court to the Mslang-Manisweni judgment. That was a relatively uncomplicated case. The only thing that the land claims court there had to determine is what would the ballpark figure be if the state had to expropriate Mala properties. Even that case took 10 days in court, and the 10 days in court is only the tip of the iceberg, taking into account a large number of expert witnesses that were called and the preparation before that case. The point that we make is saying that the court is the final arbitrator is no answer, because the first step in the whole expropriation process is that some person in some expropriating authority's office must decide to make an offer to the owner of property. That person may have very little or no legal knowledge. That person is now influenced by what he reads in section 12.3 and 4, not 4, 12.3 of the Act, saying that you may consider offering no compensation. That's the starting point. Why is that unconstitutional? Because section 25 of the Constitution starts at the other end of the spectrum. What we should remember is that when the state expropriates property and has to pay just and equitable compensation, the payment of that compensation is to the person who is losing the right. So that's the starting point. And we've illustrated in the basic argument that the convenient starting point in the cases post-1996 is that the court said, let's start with what is the value of this right in the hands of the person, starting with the market value. Of course, market value is not the only factor, it's also not the most important one. But it's the one factor that you can easily put a value on, or easily in inverted commas, because it takes sometimes a lot of evidence to determine what is really the market value. There are so many factors. But that can be quantified. Then you have to look at the other factors to see should there be an upwards adjustment from market value, and cases where that happens are quite easy to think of, where the property owner as a business that is affected. There are moving costs. Things like that should be added on. But there are also many examples where it may be just an equity to start deducting from the market value. And certain factors would count against the owner and justify less than market value. But the starting point is what do I, as the state, pay the owner to compensate him for his loss? Section 12.3 starts at the other end. It tells an expropriating authority, and also when the matter comes to court, no, don't look at what is just and equitable. Start with what is the loss. Start with the question, is this, because it falls into this category, is this not the case where I should consider no compensation? We start at the bottom and then work up. And that, we say, is not in accordance with the structure of the Constitution, and it is unconstitutional. And we have made the remark that abuse itself is, of course, not a reason for declaring something unconstitutional, but that is not what this is all about. It gives a signal to expropriating authorities, good and bad, that you may consider no compensation. We say nil is the equivalent of no compensation.
Mr. Wenger, let's talk about that signal that you talk about to the official. So, if you accept that less than market can, in circumstances, be awarded, notionally, and without being facetious about it, could R1 be an appropriate amount after the entire exercise of just and equitable? R1.
My learned friends on the other side argue that the Constitution makes it possible to come to a calculation where no compensation is payable. But they all say and admit that this would be an exceptional case. I cannot personally think of a case where the property that I hold can be worth nothing. I can't figure it out. But the real question is, if this is exceptional, it can only happen in an exceptional circumstance, as they say. Why is it here in the Act listing 4 categories and leaving it open in it to say, well, in these cases it may be exceptional and possible if the Constitution really allows. And I'm not conceding it because I can't get my head around it, but you can get nothing for your property.
I want us to move, Mr. Williams, I want us to move away from the no.
Yes.
All I want to understand is it conceivable that R1 or 10 rand or 20 rand,
Let's call it low compensation.
no compensation, could be awarded?
Yes, it is conceivable, and there will be such cases. But that's no justification to say.
No, I'm trying to understand. So notionally, somebody could be given R1 for their property
Yes.
after an exhaustive exercise of going through all of this. The only question is that whether it's less than R1 and it's nothing. Now, I don't want you to be facetious about it, but
No.
if as you say, the signal to the official is you can give no, then you take away that signal and you say possibly R1. It could be as low as R1. So the signals to the officials doesn't help us in this debate. And that's why I had the discussion with Mr. Duplessis about let's leave the official aside, whether they've got the capacity, whether they've got the skill, and whether they've got the knowledge. This takes me to an issue that you raised, and that is the role of the courts.
Yes.
And what the courts do is to, over a period of time, try to set a standard in which legislation is to well, firstly they will interpret it and then to be applied, the application of legislation. That's what the courts do. Courts need to give to whether it is the official or the ordinary citizen as to how to conduct themselves, their behavior, whether it be criminal or for officials, how they administer laws and exercise their powers. It's the role of the courts. And the courts will set those standards, and the courts will give clarity. And that's where it's going to be for the next, I suspect, 100 years, that the courts are going to have to play this role in interpreting and giving a directive to state officials and to the public at large as to how they conduct themselves. For the public and the state official as to how to apply the laws. It's going to be and sometimes you'd get the big case that in which the Constitutional Court is able to strike down very clearly and set the example clear. Then life becomes easier after that. But they are going to be one can imagine, as you correctly point out, fairly complex issues that are going to meander their ways up to the courts. And that's the sense that we must have in the courts and the judiciary over the next 100 years to do that.
Yes, I fully agree with that. But that is part of our problem. This section, the courts will doing that exercise, and there will be really difficult cases. Well, most of those cases are difficult, but there will be some that will be really difficult. Courts have to apply standard of section 25(3) of the Constitution. That is what they have to apply. Courts need not be prescribed by section 12(3) of the Expropriation Act how to go about in that exercise. And that is where we say this deviates from the structure, the constitutional structure of section 25(3) by not only prescribing to expropriating authorities where the process starts, but to the courts, how they should do their job. And that we submit transgresses into the court's duty, and it oversteps Parliament's duty. Parliament is not there to prescribe to the court how to do its job. And that is really one of the bigger problems in our approach.
I just want to make sure, you keep using the word prescribe to the courts. You accept the provision is not drafted in peremptory terms.
Yes.
But you say regardless what its function is to put something in the judicial officer's mind. I don't know what the terminology would be, but
Prescribe is not
direct perhaps.
Yes.
All right. So
perhaps a better word is it suggests.
it suggested.
Yes.
And so, but you do accept what they all say, that the provision is not drafted in peremptory terms, and in fact it's a wide open. You say, so why have it?
It sends out the wrong signal. Perhaps signal is even a better word than prescribes. It sends out the wrong signal, and that signal offends the exercise that the court has to do under section 25. That brings me more or less to the end of the opening address. I wonder if this is a convenient time.
It's 3:30, so
I can carry on.
please do, so
Yes.
we get as much in as possible.
I appreciate that we have that time. I'm going to now go to the structure in the Act, or in the Parliament, and the argument really starts in section B about the Parliament, that's at page 10. It is in volume 6 of, as they were, 6 of 9, as they were marked.
Sorry, Mr. Duplessis, what page is that, please?
I'm going to start at page 10. It is under the heading, section 25 of the Constitutional Claims.
Trying to see where the emperor is. Is he seated?
Yes,
Is
he was sitting here.
Has he left us?
I've spoken to him. I didn't see him.
Does anybody know why he's left? Sorry about that, Mr. Avenga. I just don't want to know, because he's the only unrepresented person before us, and we need just to make sure that he's properly accommodated for. Yeah. Will someone just check to see if he's outside and if he's okay? Yes, please. Thank you very much. Page 10. Thank you, Mr. Avenga.
Shall I carry on?
Certainly.
The starting point been calling the judges. It's not that difficult. I've been practicing the land court for the last many years, and there we started with that immediately, which makes a lot of sense.
Yes.
Let's start with the constitutional framework, because determining whether the Expropriation Act is constitutional, we have to measure it against the Constitution, in particular Section 25. We wish to emphasize the following propositions right up front. Firstly, Section 25 of the Constitution is both transformative and it's protective. The Constitution adopts in Section 25 both these concepts. It protects property from arbitrary deprivation and uncompensated pay. But it also authorizes expropriations in the public interest.
Sorry, Mr. Wenger. It's
Judge, I couldn't find him. I think he got tired and he left.
okay.
I don't see him around.
Good. Well, thank you very much for going to check. Thank you, Mr. Wenger.
Secondly, land reform is expressly included in public interest, as I've already submitted. Some of our colleagues sometimes explicitly, sometimes implicitly say that AfriForum's case in striking down sections 12, 3 and 4 would obstruct land reform. It would not. Expropriation for land reform remains competent under the Act without those two sections, and it's competent and justified under the Constitution. Thirdly, Section 25.3 of the Constitution is the compensation discipline. I've already submitted it does not describe the market value as the sole measure. It does not entrench the willing seller, willing buyer formula. We've addressed to some extent in the ESF argument to say that there's a popular misconception out there that willing buyer, willing seller means what is an unwilling seller going to accept before he sells. No, that is not so. That is where I want to sell my property and someone wants to buy my property. That's an objective exercise. That's nothing to do with someone who does not want to sell the property. If there is such a person and the state is there to purchase it, the state has the obligation or the power to expropriate. So let me just say something about that popular misconception.
But isn't that part of how it just permeates that sometimes I myself don't understand what willing buyer and willing seller means.
Yes.
People enter into a contract. And the notion of willingness and unwillingness is most unhelpful in this entire discussion.
Yeah. First point we want to make about the constitutional framework is this. The question is whether ordinary legislation may identify more compensation as contemplated itself, and we submit nothing. The Constitution identifies relevant considerations. It does not create categories of uncompensated expropriations. And in the height of argument, and I don't have to repeat this, we do say the historical context within which this Act came about is of course important. And one of those factors is the attempt there was to amend Section 25.3 of the Constitution to make provision for no compensation. And when that failed, politicians were quite open, and we quote Mr. Lamola, who said, well, we will now simply use the Expropriation Act to achieve what we could not achieve by amending the Act. That is part of the background to what we have in Section 12.3.
Why do you keep raising that? That's majoritarianism, constitutional democracy. Why is it an issue?
We do not really make an issue of it. We just say this is the thinking from the expropriator side, because the state is in going to the biggest expropriator, they want to expropriate property while not giving compensation. That was the aim. That is why Section 12.3 was written in to make provision in a list of circumstances where they can offer no compensation. They say they can offer no compensation. Our argument, our submission, is that you cannot use ordinary legislation to try and override the Constitution in that manner when you attempt to change the Constitution power. So the point is as simple as this.
But don't they accept that you can't amend the Constitution by ordinary legislation? That's not what they're attempting to do. They're simply just not competent.
Yes, no, you cannot do it, but
And-
we say that is that is the effect of Section 12.3.
And they also say part of that debate takes us nowhere, because when the amendment was before Parliament, people voted very differently and had very different ideas about how Section 25 should read. And so it doesn't, if you take, for example, the EFF who voted against the amendment, I've got no idea as to why they did, and how they support this legislation. It's almost incongruous. But,
That's politics.
that's politics.
But luckily we're not here to argue politics.
Yeah.
We are here to argue very important constitutional principles and protecting property rights. And that is what this case is respect about. We've quoted on the next few pages from the TUI, this is Minister of Transport, our bundle of authority studies at page 347, if you want to note the important parts of the TUI, we have quoted in the answers as well. And it simply says that the list of factors in Section 25.3 is an open-ended list. Not all factors will be relevant in any particular case. Some factors may not be relevant, and the court has to decide which factors are relevant and then make a determination. We've quoted also extensively from the minority judgment there, which says that starting with market value is I don't know about the other case, but this judgment started with the two-stage approach, determining market value, and then see if it should go upwards or downwards. In some cases, that approach is criticized, and I think it was Justice Longo said there's only one test, and that is what is just and equitable. Because in the end it's one test, but you have to start somewhere. You cannot pluck a figure from the air. And that is why the convenient point is to start with what is the value of the property in the hands of the person whose property is taken, and then start your exercise. And that will probably be refined by the Constitutional Court and courts dealing with compensation cases in future. It doesn't play a large factor in our case.
But Mr. Avenger, isn't that going to be the approach of the courts? Courts had a particular approach when it came to the 1975 legislation,
Yes.
and that's all they had. And given the 1975 legislation where market value was the yardstick, so the courts had these two-stage approaches. It started with market and then we work down. That will fundamentally change when new legislation is put before it that is meant to be congruous with Section 25. It can't start at 1C. It has to start at wherever the court may decide to start. But it really can't be C anymore. Market value, and then we do a subtraction sum. It's not formulaic. That's the difficult nuances the court is going to have to be faced with.
And we do do have examples of case law. For example, there's a land court case that we quote, ex-parte former Highlands residents in the Ash, and we also quote from that in paragraph 18 of our heads. The land court had to make a determination not based on the Expropriation Act, because that statute said you have to look at the Constitution. And even in that case, the land court, and it was deciding over by Judge Fildenase, if I remember correctly, who's one of our experts on expropriation law worldwide, say that you have to approach the determination of compensation in a practical manner. And the best way in this case to do it is to start with the market value. There may, of course, be cases where you start at a different place, but you have to start somewhere and then factor in all the...
But can a court determine where you must start? Why should one court say you start at market value? Here you're going to be dealing with new legislation. And is that not going to be a distilling process over the years as to the approach of the court?
I think the answer is simple as this. Section 12.1 repeats Section 25.3 of the Constitution. That is the test. We already have that in the Expropriation Act in Section 12.1. It's not one of the sections that we attack. So it is there, and that is the test that the court will apply. And our problem is pointing towards the starting point of full compensation in Section 12.3 of the Act. And that is what we say the vice in this Act is where it goes off the rails, where it becomes unconstitutional. This Section 25.3 is there, it's repeated in Section 25.1. The fact that the words time and manner of payment are not there is not in our submission from our side the problem, because other sections in the Expropriation Act determine that. It says when payment should be made, how payment should be made. And for example, it says, I think it's sections 18 and 19, when the compensation is being determined, then you have to look at whether there's an outstanding mortgage bond, whether there are outstanding property rates and taxes, and those persons or entities are paid first from the compensation. Maybe in the end of the day, the owner gets nothing. It's not because he didn't get compensation. The state is the expropriator, and paying the compensation is now paying your debts on your behalf out of the compensation money. So the time and manner of payment is dealt with. We do not, from our side, see a problem in that. The answer to your question with respect to Section 12.1 of the Expropriation Act repeats the test of the Constitution, and that is what the courts will have to apply. That's what the courts will deal with, and the courts are fully equipped to do that. And if you get an inexperienced judge who has it wrong, we have a number of higher courts who can deal with it. So these matters are always difficult. There's always someone higher up who may think differently.
That's the point. You know, at some stage, the courts will hopefully be able to give the appropriate approach to dealing with these matters. And at this stage, simply to rely on the approach the court adopted in the 1975 Act might not be the starting point.
Yeah. No, we do not do that, but we repeat what the interpretation of Section 25.3 was in light of that, but also without in cases where the old Expropriation Act did not apply, and a very similar approach was taken.
But the only thing I'm trying to understand is the distinction between the interpretation for constitutionality and the approach to be adopted by a court with regards to the determination of disputed compensation. It might well be very different. The interpretation at the end of the day will crystallize as what the Constitutional Court eventually decides.
That is so. And we will have the development of case law and of the expropriation law in view of the new act. But that should be, in our submission, worked out, section 12, 3 and 4. Is this a convenient time to?
I think so. So, yeah. My sister screams yes. Lest I keep you here any longer. So, thank you, Mr. Avenga. We'll start with you again tomorrow morning at 10.
It's at the end of the middle.
Yes. And thank you, everybody, thus far for a very long day, start of the week. And hopefully we'll get through it by the end of the week. If not, I do not even want to contemplate that. But thank you for your attention and your cooperation thus far. So we see you at 10 o'clock tomorrow morning. We adjourned. Thank you.